It all started with a 911 call. Two women, a mom and daughter, were brutally murdered. Betti Suzanne and her daughter, Christina Donzero, stabbed to death. Christina's body was reportedly found dismembered. The killer, police say, is Christina's live-in boyfriend, Kirk Hysell Jr. According to detectives, Hysell allegedly confessed, admitting not only to the killings, but revealing he had planned to kill the entire family. I'm your host, Kennedi Walker, and I'll walk you through the crime scene, the investigation, and the disturbing details. For this story, we go to St. Petersburg, Florida. Christina Donzero and Kirk Hysell Jr. had been together for years. They shared a life and a home together, but it would be inside that very home where police say Hysell committed a brutal crime. Christina and her mother Betti, known to loved ones as Suzanne, were murdered. According to documents obtained by Law&Crime, around 10:15 a.m. on April 12th, Hysell's daughter called police. She reportedly told dispatchers that Hysell had killed his girlfriend and his girlfriend's mother. Police rushed to the scene. When officers entered the home, they found Christina and Suzanne both stabbed to death. 34-year-old Christina was found in the bedroom, her body reportedly dismembered with multiple stab wounds. Her 75-year-old mother was found in the garage. Documents detailed that Suzanne had been suffocated with duct tape, then stabbed. Inside the house, Hysell was found in the bathroom. He had multiple self-inflicted injuries and, according to reports, told officers he had been trying to kill himself. Hysell was reportedly rushed to the hospital. According to the Pinellas County Sheriff's Office, he later admitted to the murders. He allegedly told investigators he had originally planned to kill the entire family. Authorities say he also confessed that if he ever got out, he would, quote, do it again. Hysell was arrested and is now charged with 2 counts of first-degree murder. At this time, investigators have not released a motive. And joining me to talk more about this is trial attorney Matthew Sarelson. Matthew, thank you so much for joining me today. Let's just jump right in. What exactly does a charge of first-degree murder mean under Florida law?
Well, first-degree murder is premeditated. It normally means that there's malicious intent as opposed to, let's say, manslaughter and accidental killing. What I haven't seen yet is whether they're going to charge him with capital murder, which would potentially bring the death penalty.
And how could he be charged with capital murder?
So Florida is very pro death penalty. It's kind of a weird thing to say, but Florida uses capital punishment more than most states, except maybe Texas and Alabama. In order to be charged with capital murder, you have to have murder with extenuating circumstances. So one of them, for example, is murder of a police officer, murder and commission of another crime. In this case, more than one murder at the same time, a double murder, a multiple murder, that's going to get you potentially capital punishment in Florida.
How many years could he be facing if he's just charged with first-degree murder?
Oh, life. He's going to jail for life. He's never getting out of jail. No chance.
And we're talking about the death penalty. You just mentioned that. And so in Florida, tell me more. You said many people that get charged with the death penalty, most likely it gets carried through.
So Florida's a fairly conservative state when it comes to crime and punishment. We have capital punishment. We use capital punishment. There are a lot of states that have capital punishment on the books, but they don't actually use it. We have it on the books. We do actually use it. We execute several people a year up in Rayford, which is where our death facility is. And this is St. Petersburg, which is Pinellas County. Pinellas County is on the more conservative side than, let's say, South Florida or Orlando or Jacksonville. It's a more conservative place. They're far more likely to charge him with capital murder, and you're far more likely to have a jury convict for capital murder in Pinellas County.
Now, detectives, they say that the suspect, he allegedly told them that he planned to kill more family members. Could a factor like this upgrade this, just that statement alone, if it is true?
Well, I don't think that statement's going to enhance any aspect of his penalty. I think that statement's going to raise questions about his mental health. I mean, this guy clearly has some kind of mental health issue in his past, given that he apparently tried to kill himself in the process, had other people in mind. This was premeditated. I'm willing to bet there's a mental health issue that's going to be raised by the defense.
Right. And police say that the suspect also allegedly said that he would do it again. So, for the defense, if they're going to raise, say that potentially he has issues with his mental health, how exactly would that go?
Well, they can raise not guilty by reason of mental defect or insanity. The so-called insanity defense. That's not going to get him out of jail. That's going to send him to a mental facility for the rest of his life. I mean, there is no way this guy's going to walk free. Full stop.
Could prosecutors also pursue charges like abuse of a corpse given the alleged dismemberment?
Yeah, there are charges that stem from abuse of a dead body, mutilation of a dead body. I suspect, given that there was some form of dismemberment, I haven't read the details. I don't know that the details have been made public yet. But depending on the details, they can certainly use that as an enhancement. Certainly makes it easier to get a life sentence or even capital murder for sure.
Yes, we're also waiting on more details. What we know so far, according to reports that obtained by Law&Crime, was that the suspect, he's accused of stabbing and killing both victims, but he allegedly dismembered his girlfriend, Christina.
Yeah, I did my own background search on this guy in advance of our call, Kennedy. I wanted to find out if there was more. I'm just convinced there's something in his past about mental health. I didn't find any. If he was involuntarily committed, which we call the Baker Act in Florida, if he was Baker acted, it's not going to show up in a public record. I looked at his criminal history. He has a couple of traffic infractions, and he appears to have been charged with domestic battery when he was about 20, but it looked like he got a diversion of some kind. So I don't see much by way of criminal or mental health background, but that doesn't mean he doesn't have it. It just means it's not available to us.
Is his alleged confession enough to secure a conviction, or will prosecutors need more?
Well, they found him with two dead bodies, so that's enough to secure the conviction. The fact that he admitted to it is just sort of icing on the cake. I mean, what's his defense? She fell and landed on my knife. I mean, come on. He has no defense. He admitted to it. He's guilty. If his criminal defense attorneys are smart, they try to plea out and save him from the death penalty.
Correct. And so also we see in cases like this, it may appear that, it's an open and shut case and the person, they come back and they later recant. But like how you said, in this case, he can recant or not, he was still caught with the dead bodies, correct?
Yeah, I mean, you can recant confessions all the time. That doesn't necessarily mean they're not coming into play. If he recants his confession, that means he would have to testify about it. So I doubt that's going to happen. But at the end of the day, he was found with two dead bodies inside his house, and he told people he did it, and then he was going to do it again. So I'm really not sure what his defense is going to be.
In other cases, can a confession be thrown out if it was made while the suspect was injured or under the influence, if they claim that they were under the influence or, distressed?
Yeah, sure. I mean, you can't coerce the law enforcement can't coerce a confession. So if this was a coerced confession, if he was coerced because he was under medication, if he's under medication of his own volition, that's different. If he was somehow, injected with truth serum or something, that's going to get thrown out every day. I've not seen anything to indicate that this was a coerced confession in any way. This appears to just be an old-fashioned "I did it" confession.
What is the significance of intent when it comes to charging someone with first degree murder?
Well, levels of intent are going to go to first degree murder, second degree murder, potentially manslaughter. And if there was heightened intent, multiple murders, murder of a law enforcement officer, murder of a judge, something like that, it's going to enhance your sentence to potentially capital murder and the death penalty.
Let's talk more about the suspect's mental state. Could, just like how we talked about earlier, he reportedly tried to harm himself, the self harm. If you were his defense attorney, walk us through how are they most likely going to try to argue this?
I think their only way out potentially is some kind of an insanity plea of some kind. What they're going to have is forensic, a psychiatrist. He's going to have to see a whole bunch of therapists, both private on his end, also state for the government. They're going to all have to say, is he competent? Was he competent at the time? Was he suffering from some kind of history of mental illness? Potentially, was he on medication for that mental illness? Let's see how that played a role. That's what I would be doing if I was his defense attorney.
And talk more, if you mentioned earlier, if they do suspect that there was some type of mental defect, they're going to put him in a hospital for most likely the rest of his life. Tell me, how that goes, because there's been a lot of instances where people, may say that the hospitals, they're better than the jail. What would, his day-to-day look like if he was committed?
So there's sort of two things in play. One is he competent to stand trial? So if he's not competent to stand trial, he would go to a state facility until one of two things happens. Either he dies or he regains competency to stand trial. And that is it's a mental institution, like it's sort of an old-fashioned psychiatric hospital. Unfortunately, some of them aren't very great. You've seen stories about them in movies and documentaries. If he was found not guilty by reason of insanity, then he would go to a mental hospital for the remainder of his life. He would essentially die in a psychiatric ward of some kind, and he'd be treated to the best of their ability. Slightly different paths.
And you said that in some cases, until they are able to be competent, then they're going to wait. They're going to see if he's competent. How does a person regain their competency? I didn't even know that was possible.
Yeah, actually, you can, sure. So if you are incompetent at a given time, that's not to say that you will be permanently incompetent. You might be suffering from some kind of a mental disease, some kind of a defect, an illness of some kind that can be cured. If you are incompetent today, but with, let's say, a couple years of psychiatric treatment, whether it's therapy or pharmaceutical, you may actually regain your competency. You do see people, it's very rare, not guilty by reason of insanity, the insanity plea. We talk about it a lot, but it happens to be extremely rare. It really is virtually unheard of in practice. But there are situations where you're sick, and 5 years down the road, you get better and you will stand trial years later when you regain your capacity. It's rare, but it does happen.
If that does happen, how exactly are they found guilty or not guilty if they allege that during this time that the incident took place, they weren't competent or they weren't in their right mind when it happened?
So there's sort of two ways that goes about. First is regaining competency means you can stand trial. It doesn't mean you are not guilty of the crime by reason of insanity. You still have to go to trial and you still have to prove the burden is on a criminal defendant to prove not guilty by reason of insanity. So if you end up going to trial, let's say 2 or 3 or 5 years down the road, whenever it might be, you're sort of back to square one as if the trial was just after the incident itself. You simply have a trial later on. The burden is still on you, the criminal defendant, to show that you are in fact insane.
And some may wonder, how exactly do people spot the difference? Because there are, in some instances where people are mentally ill, they are sick, and that's why they may have committed the crime. But in other cases, people, we find that they were fine and that they did it just out of pure evilness, if that's even the right word for this. How can people tell? Because just listening to it, you hear someone stabbing someone to death, allegedly dismembering someone. Of course you think, oh, something may be wrong with them, but how do you know that it's not just something that they wanted to do and it has nothing to do with mental health?
Sure. So in the event of a question about competency to stand trial, that decision is going to be made in front of a judge. Only the judge will determine whether you can stand trial. You'll hear from experts on both sides. If there is, in fact, a trial and you're going to plead not guilty by reason of insanity, then the jury is going to have to listen to both sides' experts. The criminal defendant, he's going to put on his experts that say he's insane. The state's going to put on their experts to say he's not insane. He knew exactly what he was doing. And then the jury is going to have to decide, who do we believe? The burden is on the criminal defendant to show that he's not guilty. It's not a burden on the state to show that he is in fact sane. It's on the criminal defendant's burden. But ultimately, it's a jury question. Who does the jury believe?
How could investigators prove premeditation versus a crime of passion here?
If I'm law enforcement, first I want to see if there's any videos, either from the house, maybe from a neighbor's house. I want to look at cell phones, maybe something got picked up on a cell phone, like a Siri or an Alexa. And then I would also talk to the victim's other family and friends. Did this person ever say, "Hey, I'm threatened by this guy. He's threatened to kill me. He's hurt me. I would be looking at anything of that sort to see if there was a fear that these victims had and expressed to other people. That would show, in my mind at least, premeditation.
Right. So they're looking through text messages, voicemails, interviewing family members, just trying to see if maybe there was a history of potentially domestic violence. I online it appears the couple had been together for a while. People think, oh, they've been dating for a while. They looked happy, but I guess we never know what happens behind closed doors, correct?
Yeah, I mean that doesn't mean anything. If the victim in this case, the girlfriend, if she was telling her girlfriends that he's threatening me, he's been doing all of this stuff, she's probably confided in her friends about what he has or has not been doing. I would be interviewing those people to find out what she had experienced in the past. The dead can't speak, but the friends can.
And for those that are experiencing, domestic violence, if they are living in fear, what advice do you give them?
It's tough. Domestic violence is woefully underreported. There is still an epidemic of victims, primarily women, who do not want to testify against their husbands or their boyfriends. It's a huge issue. Judges deal with it all the time, where a woman recants on the witness stand, and a domestic abuser will go free. It's tough. You need a support system in place. You need law enforcement to be helpful and cooperative and understanding. And you need judges and juries who sort of understand the dynamics in play. But there's no really good answer to that question.
So can you walk us through the next steps? The suspect has been arrested. What happens now?
My understanding, he's still in the hospital. At some point, when he's medically cleared, he will be transferred from the hospital to the Pinellas County Jail. He probably has had, if he's awake, I don't know if he's awake and conscious. I don't know what his condition is. He probably has already had, or he will shortly have, his first appearance. This is when he has announced what he's charged with. He'll be appointed almost certainly a public defender. I don't have any reason to believe this guy can hire his own counsel from what I can tell. And then in the near future, he will be arraigned, formally charged. He will formally plead either not guilty, unlikely guilty, or maybe not guilty by reason of insanity.
How soon could this case realistically go to trial?
Assuming there's a trial, and I suspect there won't be a trial in this case, my guess is there'll be a plea agreement of some kind. But assuming there's a trial, you're probably not looking for a trial date until at least a year out, maybe 18 months or longer. If they seek the death penalty, that changes the dynamic. You have to bring in death certified, court appointed criminal defense attorneys. It's a much bigger, longer, drawn out process. So if they do seek capital punishment, you're probably looking at a two-year window for a trial.
And how long does it take for them to decide if they will make this a capital punishment case?
I mean, they could have already decided. They have to at some point file a notice with the court saying notice of intent to seek the death penalty, because that invokes certain additional procedural safeguards for criminal defendants. He has to get a certain kind of death certified. It's a weird way of saying it, but you have to get a death certified criminal defense attorney appointed to you. They may have already made that decision. They probably just haven't filed anything with the court. But my guess is within very short order, we'll find out whether they're going to be seeking capital punishment for him.
And if they don't seek capital punishment, I know just a little while ago you said that this may not even go to trial. Why is that? Why could that even be an option?
Yeah, I mean, I'm not sure what his defense is going to be, right? So he's going to go to trial. His conviction is almost certainly going to be assured. And then the question is, does he get life imprisonment or does he get capital punishment? He could actually plea and then just have a trial to determine whether he should get the death sentence or just life imprisonment. But none of that really makes sense, right? I mean, his guilt is, look, I understand everyone's not guilty until proven otherwise, but the guilt in this case is pretty self evident. So I'm not sure what the benefit for him going to trial is. His much better option is to throw himself sort of on the mercy of the prosecution and the state and do some kind of a plea to avoid the death sentence.
Well, if and that's only if it's a capital case, right? With the death sentence, but what exactly would he lose by going to trial if you were saying that he doesn't really have a lot of options here? If he chooses the plea deal and not to go to trial, what's the difference if it's both potentially could end up as life in prison?
Well, the benefit to him is that if he can strike a deal with the prosecution to avoid capital punishment, he would not force the state to put on their case, basically. He would just plea. There'd be no trial. It would save the state money. It would save the victim's family from having to go through a trial, from putting on impact statements. And they might agree in exchange that they will not seek capital punishment, that he will simply plead guilty for the two first-degree murder counts, and he'll get life imprisonment. And that's the end of it.
Absolutely. Well, this is something that we will be watching closely. Thank you so much, Matthew, for coming on today.
Thank you for having me.
Christina and Suzanne Donzero are survived by family, including Suzanne's husband, Christina's father, and Christina's brother. Their family plans on burying them on May 9th. For Law and Crime, I'm Kennedi Walker.